All right, hello everyone, and welcome to this edition of MCA Canada's podcast. This is a time where we're going to explore trends, innovations, issues impacting mechanical contractors across the country. And I feel very fortunate today to be chatting with two very experienced individuals in our sector and in the industry. I'm here with Anik Forstall and Patrick Thompson from McMillan LLP. As I mentioned, both Anik and Patrick have a wealth of experience in the industry, and both are here to talk about a really relevant issue for our members and for the industry today, and that's supply chain and price volatility. So Patrick and Anik, thank you both for being here with us today. I won't do any bios or introductions. I'll turn those things over to you guys. So maybe Anik, we'll start with you. Maybe you can tell us a little bit about yourself, your background, and your experience in the industry.
Yeah, thanks, Ken. So my name's Anik, and I am a partner at McMillan. I practice construction and development law. My practice is really front-end focused, so I work a lot in the procurement and contracts phase, helping our clients negotiate contracts, decide how to structure their relationships for their projects to help them be as successful as possible, and how to manage issues that might arise during construction, including supply chain and price volatility issues. So very happy to be here today. Thank you.
No, thank you. And Patrick, how about yourself?
Thanks, Ken. So like Anik, I'm also a partner at McMillan LLP, and I'm based not too far from where you are here in our nation's capital in Ottawa. So my practice is really, focused on construction litigation. And I've acted for many local and national stakeholders in the industry. I've had pleasures of working on great, wonderful projects, both locally and nationally for the last 15 years. And I have the fortunate, or sometimes people can say the unfortunate role of dealing with disputes that often, develop on these projects. And many of these disputes, and definitely lately, involve some issue with regards to supply chain, and almost all of them have a cost escalation component. So I'm dealing with these issues on a daily basis, and have been dealing with clients who are dealing with this directly as a result of this, supply chain chaos our industry is dealing with, but in fact, the entire world. So from a litigator, I deal with this on a daily basis, and thank you very much for having us, and look forward to our discussion.
Well, yeah, and why don't we take it from there, Patrick? Because as you mentioned, this supply chain issues, price volatility, these are not new issues for the industry, for the sector, and it seems to be somewhat cyclical. But as you mentioned, this is something. It feels almost broader. It feels larger. So, from your perspective, how did we get here, and how bad is the issue right now, and what are the the big things the industry is facing with respect to supply chain right now?
Yeah, so good question, interesting question. From where I stand, again, as a litigator, as a member of McMillan's National Construction Group, my answer to how bad it is I must say it's pretty dire from where I stand. Now, remember, I'm not in the trenches with your members bidding on jobs or negotiating contracts. Anik may be able to comment as part of her practice on sort of that front end aspect of things that you mentioned in her introduction. When I get involved, there's already a problem. So, my job is to try to find a solution. So as I mentioned, all of my active files, they have a supply chain issue involved. I think, how do we get here based on your question? I think the current issue is based on, the pandemic. I mean, it's caused from the pandemic. And that's really disrupted, everything, our entire world, our personal lives and our professional lives. But that disruption, I think we're 2 years into it, that disruption has continued. And on the matters that I'm dealing with, it's evolving. Right now, we're dealing with, skyrocketed increased transportation costs, for example. The cost of shipping has gone through the roof. So there's delays in ports, whatever port you're dealing with, either in Canada or internationally, there's some issue going on in the port. So there's a lot of instability in the markets, and that instability is felt on projects. So when you ask how bad it is, from my perspective, not to sound sort of like the pessimist in the room, but it's severe on the matters that I'm involved in, and we're not at the end of it. I got clients who are involved in projects, and the materials were supposed to be delivered this summer, right? The materials have not yet arrived, and it's cold outside, right? There's snow on the ground. What does that mean? Well, now we're dealing with winter construction, so there's another cost. So it's that domino effect that the supply chain issues has created delays, but in my view, sort of the most important one is that increase in cost. So simply, I don't know any project that has not been impacted by this issue. And I don't know any stakeholder in the industry that has not had to at least deal with it or at least consider these supply issues.
Which I think leads us to a good transition to talking to you, Nick, about your perspective on this too, because dealing with the front end on the procurement side, on the bidding side, what are you seeing right now with respect to supply chain price volatility, and how is it impacting that part of the construction process?
I think on the front end, what we're seeing is just more difficulty in the procurement stage, particularly where owners ask for extended periods of time between the tender issuance, closing of the tender and acceptance. So when you're being asked to hold your pricing for well beyond 30 days, 60 days, 90 days, this can put the bidders, the trade contractors, in an impossible position. So that results in either fewer bids, no bids, higher pricing. Certainly as well with the supply chain volatility, just to try to, or market pricing volatility, trying to price that risk in is leading to increased pricing. So one thing that we are seeing is, for example, bids coming in well over budget. So in Ottawa recently, there was an article that came out about the Ottawa Library, where the city budgeted 190 million for the project, and their lowest bids were coming in over $330 million. So this is what we're starting to see at the front end. And so you see all parties in the chain, owners, contractors, trades, all trying to figure out how to manage this. I do think that in part that's going to be owners needing to manage some of their expectations. You can't expect your project parties, your contractors, your trades to carry all of this risk for you. And so, considering things like shortening the bid acceptance periods, understanding that estimates and budgets are going to be subject to change, and that sticking to those budgets and estimates is going to be difficult for anyone. And, where something does come in way over budget, that doesn't necessarily mean that your consultant or your contractor has done a bad job in preparing them. It's just a reflection of the reality in today's market.
And I think, Anit, we've talked about this previous to this conversation today. The status quo within a contract, as you pointed out, is that contractors are going to bear the brunt of the risk with respect to cost and price volatility. And in the context of mechanical contractors and trade contractors across Canada, how is that being reflected in their contracts now? Is there more risk that they're taking on, or is it just reflective of the supply chain crisis impacting that risk?
So certainly, as you say, like most of the contracts that we see are for fixed fee, stipulated price contracts. And those contracts, like a CCDC 17 or the CCA 1 subcontract, which goes under also a fixed fee CCDC 2 contract, all of these contracts contemplate only limited circumstances where the contract price can be adjusted, where it can be increased. And supply chain impacts or price market volatility are not one of those circumstances. And so unless you are negotiating terms at the outset, recognizing that this is an issue in today's market, and so raising it at the time of negotiation so that you can put in a price escalation clause, so that you can adjust the schedule or other expectations to address those long lead times and supply chain issues, If you're not doing that, then the status quo, the default in a lot of these contracts is going to be that you bear that risk. Further, with delays, even if we're not talking about price impacts, we're just talking this material, this product that I need on site is not going to be here for another 2-3 weeks. As we all know, a lot of our contracts, not the standard forms don't have this, but we will see owners providing contracts with liquidated damages and other significant cost consequences to delay. And so in that circumstance as well, these contracts provide limited instances where you can get an adjustment to your contract time, to your key schedule deadlines. And so you need to be thinking about all of this when you can upfront before you enter into a contract, before you issue your bid, flag any issues, where the schedule isn't, or the proposed schedule isn't appropriately accounting for the realities of today's market, price for that potential volatile market pricing. If you can't get a price escalation clause in your contract, these are all things that need to be considered, communicated, and managed as well as possible up front.
Yeah, and I'll just add to that, Ken, that again, from where I stand, even you talked about the status quo and the contracts that are already out. It's important for everybody involved in those contracts to understand and appreciate what the contract says, right? So if you have the opportunity at the outset to renegotiate or include some of those provisions, absolutely, that's great. But I find that oftentimes when we're dealing with these crises, sometimes there's a lack of appreciation for what the contract actually says. So that's sort of, when I hear Anik talking there, it reminds me of making sure to appreciate what your rights and obligations are in the contract that you currently have.
That's a really good point, Patrick, because I think something so often that, and I think we feel this, it's a natural inclination that, like, if something completely unexpected happens, like the pandemic, which then leads us to this market circumstance, and now my pricing that I promised a year ago has just gone out the window. We're thinking, well, that's not fair. It can't possibly be that I'm supposed to eat those costs. But unfortunately, the reality is, if you've signed a fixed fee contract, the likelihood is that, yes, you are taking that risk. And unless you can find something in your contract to hang your hat on, like tying it to COVID and being able to argue that it is a force majeure or something like that, those can be uphill battles. But absent something like that, the default is you're probably going to be bearing that risk, even though it is unfair and something that we would like to think, or we might be surprised to find is actually the risk we've taken on.
Now, this reminds me of something I wanted to add at the start of this conversation, and I do want to get back to some of these remedies and potential considerations. But as is always the case when we are talking to lawyers, and we appreciate the time with both of you from McMillan today, we should clarify that none of this does constitute legal advice. This is being shared for information purposes only. So I just want to I'll preface the conversation at the start of this as well, just to add that point, because I think that's important, because you guys are giving some great context to the discussion and to the issue, and some potential solutions, but I just want to make sure that that's clear as well. The other thing I want to bring up.
Sorry, I was going to say thanks for that, Ken. I was actually thinking about it, and often people joke around with us all the time saying, well, every time you speak, you're giving legal advice, but it's so dependent on the facts of every case. So for the listeners here, we're happy to assist when needed, but we're talking in general terms here, just based on general, discussion points. And yeah, as Ken mentioned, can't constitute legal advice. We don't know too much about the particulars of every dispute.
Yeah, and I think that being said, I want to make sure we can have you guys back on, because this is important information you guys are sharing, and some good insight as well. So I want to make sure we're clear on that for anybody who's listening here. The other thing I wanted to bring up that we alluded to earlier, there's two distinct issues here. There's the issue of obviously supply chain and the access of supply, and then there's the issue of price volatility. And I think we can treat them as distinct issues, but as symptomatic of this larger problem. But from your perspective, and I'll turn it to both of you, is one having a greater impact than the other? And is one more likely to cause an issue from your perception and from where you're sitting right now on a project?
I don't know if you want to go first, Patrick, or I'm happy to jump in, I guess.
Go ahead.
I would say from just like when you're looking at the standard form contracts, I guess, first of all, they obviously feed on each other. When you have supply chain issues, you then get lower supply. So then demand goes up. So then pricing goes up. And so they feed off of each other. And so they can't be completely, you can't just say this is a supply chain issue or this is a price market volatility issue. But as we were just talking about in contracts that are fixed fee, the price volatility risk is much more regularly or is typically clearly placed on the trade contractor. Whereas, oh, I'm so sorry. Whereas the schedule impacts may have an opportunity for relief if you can tie it to something that is beyond the control of the contractor. So those force majeure clauses have a little bit more potential to be available to you to provide schedule relief when you have supply chain impacts, to the extent that you can tie them into one of those force majeure events. So if you can tie it to something like the pandemic, then you may have a stronger case to get that relief. Whereas the cost impacts under these fixed fee contracts, it's going to be more likely an uphill battle to get that relief. And then the other thing I'll just say is that, in terms of what issue matters to what contract, it really does depend on the scope of the work and what's being supplied. I think DCN published a chart on December 3rd showing price fluctuations in different construction commodities. And on a year-over-year basis, ready-mix concrete went up 3.2%, but the price of communication wire and cable went up 77%. So you can see that the importance of these issues may, vary depending on what you're supplying, where if you're supplying those wires and cables, a price escalation clause may be absolutely critical. Whereas if you're supplying ready mix concrete, maybe you're a little more prepared to bear that risk. So it really depends on the specific circumstances, again, like Patrick was saying.
And I absolutely agree with what Anik was saying. And from my perspective, to answer your question directly, I would say price is the bigger problem, or the bigger problem that I'm seeing. Unsustainable prices result in cash flow issues, right? And which then has that, as Anik mentioned, that direct relation to projects being delayed, right? If the trades can't buy the material, even if it was available, that's the problem, right? The fact that it's taking longer actually becomes irrelevant if you can't, afford it. So again, from a litigator's perspective, as Anik mentioned, parties should or usually can find a way to agree on what we call an extension of time, right? If they can directly relate it to a delay that is directly attributable to the pandemic, or a ship being stuck in the canal, or some event, normally there is a way of finding agreement on an extension of time, and that can help with some of this supply chain chaos that we're sort of dealing with in terms of mitigating some of the delays. But prices is the bigger problem, from my perspective. I'm not seeing many, stakeholders willing to, voluntarily open up their wallets and say, okay, yes, I understand, I'm going to pay for that increases. That's where the majority of my disputes are being focused. As I mentioned, parties can be reasonable with regards to time. Everybody's experiencing the issues of pandemic, but when you're talking about your bottom line, that's when I'm not seeing that much agreement in terms of compensation. So, and as Anik mentioned, the daily commercial news, those fluctuations of those prices that she mentioned, the concrete mix, the ready mix, and the cables, or even the iron and steel pipes went up to 73% or something. Those are huge fluctuations. And when you have fixed price contracts like that, your members are taking the brunt of it, right? Even when we're talking about the larger players in the industry, right? To use the example that Nick mentioned about the Ottawa Public Library and Archives Canada joint facility, those are, we have the large players involved in those projects. But I can't remember the numbers that Anik was mentioning, but I think it was 193 was the original, and it ballooned some 60% based on my recollection of
it's like 330, something like that.
Exactly, right? Even, I don't care who you are, those fluctuations are almost unbearable, right? You can't really, Anik talked about sort of building into the prices and sort of budgets, pricing that's over budget. Well, you can't really have that budget or that contingency, right? You don't really build in that float that would cover such a fluctuation. And based on the contracts that are currently out there, there's no real provision with regards to sharing of that escalation. So again, the contractual terms, I don't want to sound like a broken record, but that's where the contract means something. The contractual terms will dictate who is ultimately responsible, and that's what the courts or an arbitrator will determine responsibility, right? That's why, back to my comment at the outset, the contracts is likely the most important thing to understand, to know clearly what your roles and responsibilities and obligations are when you're dealing with these sort of crisis issues.
And one of the unfortunate realities in the market is that owners are expecting their contractors to insulate them from this risk. They are trying very hard to lock in all of their contracts for supply, labor, everything as early as possible so that they can secure the pricing today before it goes up again in 2 weeks. So they are looking to those project parties to take on that risk. And I haven't seen that expectation shift yet. I mean, I don't mean to lay that at the feet of all owners. I mean, certainly a lot of owners are understanding of this and are team players, but at the same time, I think the dominant force in the market is this expectation by owners that this risk is something to be borne by the contractors, the trades further down the chain.
And that's exactly sort of the impact on the contracts. That, I was talking about the contracts and sort of what we are seeing. The contracts are structured, most of them at least are structured that, the risk is allocated to the trade contractors, for example. So what I'm seeing from a litigation perspective is that I'm seeing sort of a rush for more notices of intent to claim, or more rushes to notify and then document and try to submit claims for these impacts, right? So again, because the contract will dictate what and who's responsible for these increases.
I want to take it from there and then come back to the procurement side in a little bit and talk about sort of how that can be managed. But on the contracts right now that you're seeing, Patrick, and in general terms, there's not a lot of room for price volatility within the contracts, as you guys have mentioned. So what other types of solutions are you seeing, or remedies are you seeing right now with those contracts that are underway to help deal with this? And is there anything that you can provide in terms of insight to the members on what they might want to look at if they are facing an issue with respect to price volatility, supply chain within an existing contract?
Yeah, and yeah, that flows well with what we were just talking about. From my perspective, again, my comments will be premised on the fact that the contract will dictate what you can or can't claim for. What I'm seeing, and this is happening on many files, both when we are, McMillan represents, all various stakeholders. We're involved in multiple sort of on all ends of projects. But what I'm seeing on many of these is claims that are sort of rooted in entitlement that I call an equitable adjustments. These are not a right, a entitlement as a right under the contract, but a lot of your members will probably start hearing these requests or demands for equitable adjustments, right? Really what that is, it's a demand or a request for either the general contractor or the owner's goodwill. It's a readjustment of the risks based on what arguably is fair and reasonable, right? But again, contract doesn't necessarily always permit that. And we don't yet have court decisions on these specific issues with regards to the supply chain chaos that we are currently living with. But generally speaking, if we look at the past, because we've got colleagues who've been practicing longer than we have, and we have clients who are telling us this is not new. You mentioned that earlier, Ken, that if you look at those previous decisions, the contracts will determine the party's specific entitlement. And again, most contracts don't provide the relief for these type of fluctuations. So, you asked about what are there other solutions? What I'm seeing is trades working hard to mitigate the supply issues, right? And there's not that much success, but there are sometimes some success stories where when you don't think there are many alternatives, sometimes there are creative clients that find ways to, offer alternative materials, right, if available, right? Or finding different ways to try to still adhere and meet their contractual obligations, but by finding different ways. Now, it has sometimes have to be a mutual understanding, because the other side of the contracting party may say, no, these are your obligations under the contract and you're not to deviate from that. But those are sometimes creative solutions. Again, this is not contractually, but these are soft ways or alternatives that I'm sort of seeing on parties trying to work together. So what I'm also seeing is the schedules being affected. We talked about the schedules, but generally speaking, there seems to be more of an understanding and agreement to provide extension of times. So there are, again, claims for extension of time. So, your members might hear the comments of, entitlement to extension of time. You're entitled to time, but not money. I'm seeing the time aspect that seems to be resolved. On the money side, I'm seeing a little bit more dispute with regards to that. So on the schedule aspect, what I'm also seeing is that some of what the supply chain issue has resulted in is that some of the contracts that are currently in place become no longer become commercially viable for the trades to complete. They can't. They can't complete it as planned and as budgeted, and especially as we have been talking about, when they are bearing the brunt of those costs. They are responsible for those fluctuations. So, where possible, they're trying to see if they can agree to revise terms or renegotiated terms. But sometimes, realistically, it ends up in situation of, contract termination or contract frustrations and arguments to that effect, because they can't actually complete the work because they're losing their shirts.
That brings us to an interesting discussion that we've had about the notion of walking away. But before we get into that, maybe Anik, you can provide some insights on those projects that are being tendered right now, and what contractors can look to help mitigate these issues for projects coming down the pipeline, and so they don't have to have that discussion about whether or not a project is commercially viable. If there's solutions they can build into the contracts, into their bids, to help deal with this at the outset, or at least right now, given the uncertainty that we know with respect to supply chain and the price volatility issue.
So I think certainly to the extent that right up front, you identify, what are the issues that I'm likely to be facing here? Is it, the price of steel? Is it the price of lumber? Is it the price of concrete? What is it that's going to be impacting me? And then further, what supply chain issues might be impacting me as well? Long lead times. Do I need advance payments for products so I can secure them now, so that I can buy them. Maybe I'm purchasing them now 3-4 months earlier than I would have 2 years ago. Thinking all of those things through at the outset before you bid, so that you have an understanding of, is the schedule that the owner has or the contractor has put forward to you, is it reasonable in that context? Is the pricing that you're going to need to put forward to be competitive reasonable in that context? And to Patrick's point, if it comes out that this risk is something that just can't be managed under the terms of this tender, under the terms of this contract, then you do need to be prepared to walk away. There's lots of construction work happening out there, and I certainly don't want to be flippant about how hard it can be to decide to walk away. But at the same time, you don't want to end up having to need Patrick's help at the end of the day because you're eating a 200% increase in the cost of your materials. So the sooner that you can identify those things, understand how they're going to affect what you're bidding on, and then communicate them. So if there is, in the tender process, that questions period where you can put questions to the owner about whether they'd be willing to consider a price escalation clause or advance payment for materials or adjustment of the sequencing or schedule for the work in order to address these realities. The sooner you communicate these issues to the project parties, the sooner a solution or something may be considered or put on the table to be available as a mitigator or to address it. But similarly, if you get the door slammed in your face and said, no, there's my contract, that's the one you're going to sign, it locks you into this pricing, I need you to hold this pricing for 60 days as well before I even tell you you're going to get the job, and period, full stop. Well, that also tells you something about the nature of the person you're going to be contracting with and the risk that you are likely to be facing when you work with them. And so then you have to take that into consideration, either price for it or decide not to participate. I think the power in deciding not to participate, especially when it's something in response to an issue like this that is industry wide, is so often what we hear when we are pushing back on RFP terms or contract terms is, well, someone will sign this. I know I will find someone who is going to take this risk on for me. I know someone's going to sign the dotted line. And that, if that is true, and when there is that confidence in the market on those going out to tender, that they can just get what they want with these aggressive terms that place unreasonable risk on the parties further down the chain, then that's not going to change. The only way it's going to change is when that stops being true, when the bidders do start to dry up, or when the bids do start coming in well over budget to price and mitigate that risk. Then maybe the owner attitude will start to shift, and we'll start to see a little bit more of that being dealt with upfront in our tenders. But I guess I would just say that yeah, walking away is not just necessarily benefiting you in that specific instance for that specific bid, but it can also help just shift the market and the market expectations in terms of what your trade, what your industry can bear in terms of handling this risk.
And I think we talked before, and Patrick, when we talked about litigation, getting to that point, and in the event a contractor is in a situation where they haven't been able to have these clauses included or have had that risk downloaded upon them, what would you say to a contractor who would consider litigation as sort of that potential solution at the end of the day?
So I'm a litigator, so it's always an option. But realistically, my practice and our practice is, to try to find solutions, right? We're there to try to fix the problem. But the conception of litigation has to be taken as a, in evaluation of all the risks and potential rewards, right? I'm not the personal injury lawyer on TV that's going to say you only pay unless I win. That's not the way litigation and construction litigation actually works. So to be honest, litigation is likely not the best solution. Most contracts that I'm dealing with do not specifically allow for an entitlement of these supply issues, right? So, understanding that and appreciating the risk associated with litigation, that has to be taken into consideration. So I think most are reluctant to file, and my advice to clients is often, have you explored all the various other options? I'm not saying that I don't litigate supply and disruption issues. What I'm just saying is that normally it's incorporated into a claim that has multiple other heads of damages. And what I mean by that is that it is included in delay claims, for example, or productivity claims. So there are other elements that contractually are a little bit, I don't like to say easier, but they're a little bit, a little bit clearer to make your arguments based on what is actually going on. So again, on supply chain and cost disruption exclusively, likely not the best solution, but if it's incorporated into a larger claim, I'm seeing a lot of that, and I'm involved in that. The issue with litigation, as I was joking around with sort of the personal injury lawyers, and nothing against personal injury lawyers, but I can't provide guarantees, right? There are no slam dunk cases. Every litigator, including myself, has lost cases they were confident in and won cases that they didn't think that they had a chance, right? The court process or an arbitration process, depending on your contractual provision, really is that uncertain realm. It doesn't matter if your lawyer is the most experienced, the most knowledgeable, has the better expertise, he or she can't actually predict how the decision will come down. And that's the risk of litigation, right? You don't control the outcome. Whereas in considering other alternatives, sometimes you can come to a compromise where you are controlling the outcome. So, back to your question about advice with regards to litigation, playing hardball and litigating is not always the fix. It won't actually fix the problem, right? It's not going to resolve the supply chain issue. It's just whether or not you're entitled to some compensation. And as a mentor of ours told us recently, the court can't change the contract terms, right? They can't turn a bad contract into a good one. The court is going to tell you what you can and you can't do, what your rights and obligation. The court or the arbitrators are going to interpret the words on the paper, right? They're not going to create new obligations. They're going to interpret what are already provided for in the decision, in the contract, and that decision will end up being binding. Whether you like it or not, it's binding, and then you have to adhere. The other thing that I'll add is litigation. It sounds obvious, but ruins most relationships, right? If you have a good relationship, a trusted relationship with either general contractors, other trades or owners, or your suppliers, and that has generated repeat business, for example, well, litigating against them, sometimes it's the only choice you have. Litigating against them usually will ruin that relationship or end that relationship. Sometimes it's worth it. I'm not saying that. However, litigating sort of creates that that precedent of not necessarily wanting to work with those companies or individuals that you've had. So I feel like I'm not necessarily selling my practice and what I do, but litigation is one thing, right? Filing a lawsuit or a notice of arbitration is one thing. There are multiple steps in litigation. We have a busy practice. I'm in court and I'm in arbitrations on a regular basis. But that being said, there are multiple steps before we get there, right? So sometimes you need to send that demand letter, right? That's, when we're talking about litigation, people have this concept that, oh, it's what happens in court. Yes, technically, but in order for me to get to court, there are steps that I normally follow in order to get there. So again, sometimes it's worth sending that demand letter. Sometimes it's worth sending a notice of intent to claim. I've even drafted draft statements of claim and sent it to the other side, because the approach, and I'm not selling secrets here, but the approach is to try to elicit a discussion, a conversation to see whether or not there can be an amicable resolution. So again, that's litigation. That's what we do. But I guess there's a difference with regards to filing that lawsuit or issuing that notice of arbitration compared to taking those various steps that are still considered litigation.
I think, Patrick, that's exactly what I was going to say. Is I think I agree entirely. Like, even at the front end, what we're trying to help do is prevent the project from ending up in litigation or arbitration. No one wants to end up there. And if we're there, everyone's losing. You know, the project has been delayed, costs have been incurred by people who, you know, can't bear them necessarily. So this is not where we want to end. But I think there is this misconception of the dispute resolution provisions in your contract. I would encourage trade contractors, everyone in the industry, to see those as a tool. They are a further mechanism available to you to bring issues to each other's attention. So saying, hey, I'm experiencing higher costs than I expected. Oh, I'm experiencing delays. That in and of itself should not be seen as an act of aggression or something that's litigious or something that is negative to the relationship. Giving your notice, which you always should do in accordance with the contract. You know, if you're experiencing something and the contract says you need to give notice within 5 working days, make sure you do that. Make sure you follow those rules. Don't be hesitant to do so because you see it as a litigation thing. You don't need a lawyer to do it. You don't need that to go out on a lawyer's letterhead or anything like that. As Patrick said, these tools are intended to get people talking, to bring issues to each other's attention, ideally so that we can mitigate them, deal with them, and hopefully resolve them amicably. And so that dispute resolution process, I would encourage everyone to see it as that kind of tool to facilitate discussion, to facilitate problem solving. I would say that even if you can't find that perfect clause to hang your hat on for your claim for extra costs or delays, issue that notice. It's not going to hurt you. If anything, it's going to paper the record that you flagged that there's an issue, you've brought it to someone's attention, and it will get the contractor, it will get the owner at the table to have a conversation with you about it, if nothing else. And that's always in the good of the project. So, and that's not a guarantee. Like, there's a long way to go from your issuing that letter to your starting an arbitration or you're starting litigation in court. There's just a long way to go between that starting point and that end point. And so they're not a guarantee that once you've done one, you're going to end up, you know, at the back end in a big fight. So I would encourage parties not to see it that way and to see it as a good tool to help the project.
I couldn't agree with you more, because when people talk about litigation and wanting to take that next step, one of the first questions I ask for when I'm trying to familiarize myself with the project is, can you please send me the notices that you provide? Right? Talking about documenting and, you know, papering the file. Those notices, as Anik is saying, they are tools provided for in the contract. You're not throwing, an arrow across, the bow. You are following the terms and conditions of your contract, and people shouldn't get upset with that. They are rights provided for in the contract, and truthfully, those are the first questions I have. You want me to write that demand letter? Okay, can you please provide me with the notices that you provide to confirm that you already requested this within 5 days or within 10 days, 7 days, depending on what the contract says. So that is, I don't see that as litigation. That is, respecting and following your contractual obligations.
What I appreciate about this conversation so far, we started talking about supply chain and price volatility. We've now moved into dispute resolution. So we've covered a gamut of issues in the industry. But I think what's really important, and what I'm hearing from both of you, is this notion of communication with all stakeholders on a project, whether it's the suppliers, whether it's the general contractor and the trade contractor, whether it's the owner or the consultant. regardless of the stakeholder, it's important that there is that communication, that discussion, and that there are these contractual provisions available to each individual party within the contract to facilitate that discussion, that communication. But I think that's been somewhat part of both of your comments so far, is that communication, collaboration is key if we're going to deal with these things, because they are issues the industry is facing. They really are outside of the control of many of our members as it is right now. And so that communication is going to be one of the most important tools that they have to dealing with this, both at the front end and the procurement side, as well as in the contract itself. So I think I might have twisted some of your words there, but is there any additional thoughts on that you both have with respect to that, the importance of that communication, or do you think we've covered it for the most part up to this point?
I think you're absolutely right. And I think, good communication on a project, good collaboration on a project, recognizing everyone is here because they want to build something together. They want this to be successful. And when you can bring that attitude to the table, that's the key to the project's success. And so, yes, it's a big part of the answer to supply chain and market volatility issues, but it's a huge part of the answer to so many of the issues that we see in construction. I think it's the foundation of successful construction. Obviously a topic for another day, but that's why we're starting to see a lot of interest in and movement toward some collaborative contracting methods like IPD, like alliance contracting, because we're recognizing that when we can collaborate and work together, communicate, and all have a bit of skin in the game, and recognize that if we, instead of just putting one issue, well, this trade contractor needs to solve that problem by himself, and if he screws it up, I'm going to hang him out to dry and just hope to insulate myself. That attitude with every project party is not the way that we can solve dynamic issues, unexpected issues like this one, which is something that, today when we go out to tender for a project, we don't know what the market's going to look like 2 weeks from now, 2 months from now, 2 years from now. And so to try to then create those silos for ourselves in a fair, reasonable way is impossible. So I think, can't emphasize enough how much just treating your project parties fairly, communicating clearly, and working together to find creative ways to solve these problems is the best way to prevent litigation, minimize delays, and keep your costs as close to budget as possible.
Yeah, and I'll just add to that, because again, I entirely agree, and Anik says it way better than I can, but that collaborative approach is so important, even for me as a litigator. And the reason why I say that is, again, there's no court decisions out there that confirms this. But from my perspective, I think the pandemic, we've talked about the supply issue as having sort of this cyclical issue, and not much has changed. But what I think the pandemic has created is that it's affected everybody. And I think the court may consider that when we get eventually to court with cases and decisions that are going to create precedents. I do think that we're going to see some consideration for that equitable relief that I talked about earlier. And, having that collaborative approach, the reason why I'm talking about that in the discussion with collaboration is I think that trying to work collaboratively with the stakeholders in the construction project or your contractual relationship can only be beneficial. Even if it doesn't resolve, even if you can't find a solution, if I go to court and present all the collaborative efforts that have been sort of, attempted between the parties, I think that may end up being beneficial. I say this because judges and arbitrators have also had to be, working from home. We're at home now. So, I get the impression that everybody has sort of that understanding of it, and may look a little bit more positively on parties that have tried to work cooperatively. I'm not saying that is going to be the case. It's just my view on things. I think the courts are going to at least think about that in rendering a decision where there might be an ambiguous contractual provision where the party that has been reasonable or trying to cooperate the courts or the arbitrators may find a way to look more favorably on that person. So I think collaboration is important. I think it's the key to a lot of solutions, and I think it's even beneficial in the context of an eventual dispute if a resolution can't be achieved.
To that point, Patrick, I'm just thinking out loud here, but I'm thinking that if you're the trade and you've communicated regularly, here are the supply chain issues I'm facing, here are the cost escalation issues I'm facing, and here are the solutions that I'm proposing to mitigate my these impacts, not only to myself but to the project. And if you're communicating that clearly, documented in writing, and you're just getting the door slammed in your face, no one's listening to you, and it exacerbates the problem, I think that absolutely would put you in a stronger position when you show up at an arbitration or in court, because you'd be saying, if my project parties aren't helping me mitigate these losses, how can they then fairly ask me to bear them all entirely? And so I do think that every time that you are trying to be collaborative, to be clear in your communications, effective in that, it will not hurt you. So even if no one listens, I don't think it will put you in a worse position than you were in before.
Agreed. And I've never heard somebody complain about too many notices or too much information, right?
I heard people complain about that,
but it's better to have too much than not, no notices, etc. Right? So I absolutely agree with you. I think there's a tremendous advantage and benefit to that collaboration.
We'll have to figure out what that equilibrium is in terms of how many notices should go out and the appropriate amount of communication. But I get the point, and I think what I've heard too is it's communicate, document, know the impact and how it affects the bottom line and how it affects the project. And if you're staying ahead of it like that, if it does go down this road where you're not able to find a solution, at least you've got that in your back pocket, and you put the effort in to try to save the project, so to speak. So
I mean, if there's any lesson, it's you cannot bury your head in the sand and hope that it'll all work out, or that a court will fix it for you later. Like that's not going to happen. You need to be active and advocating for yourself in this market.
Listen, this has been fantastic. And I think we could probably spend another hour, 2 hours talking about this and many other issues the industry is facing. But I want to be respectful of your time and the time you've taken to talk to me and to talk to the membership about this issue. And I'm hoping that this can transition to more discussions about similar issues that the industry is facing. So I really do appreciate both your time, and Nick, Patrick. It's been very insightful. What we will do is I'll share your contact information if you're okay with that. If anybody has any additional questions, they can reach out to you, because I think, and I know in my own personal conversations with both of you, there's a wealth of knowledge here. There's a lot of really important discussions and fun discussions too. So I appreciate both your time, and I know the membership will as well. So thank you both.
Thank you, Ken.
Thank you, Ken.